But the question...
Counsel, I'm having, because I think the Chief has asked a very important question. Let's break that down in examples, okay? Facebook is somewhat easier because people can be blocked from commenting, but they'll still have access to looking at the information, right? But let's assume that there's something went wrong with the city's website, and the city is now asking the council member to post all of their evacuation programs and to have comments with respect to citizens who might need assistance. They've converted it into basically an official site. So how does your test deal with that? Because you said if it's mixed personal and business, then it remains personal.
Well, so on that hypothetical, I would agree that would be state action.
So the state would be responsible for any blocking that this individual had done of commenting people?
Yes, but the critical reason why, and the why that follows from our test, is because in your hypothetical...
By the way, is your test identical to the Sixth Circuit's duty and authority test? Or authority test, or you use the words control or facilitate, which the Sixth Circuit didn't. So tell me what's the difference in what you're proposing.
We think duty or authority is the right test. The hard question in these cases is figuring out whether you're exercising duty or authority. Control and facilitation is the way to figure that out, and that's the answer to your initial question.
Well, the Sixth Circuit is much narrower. It defines duty as something stated by law. But frankly, in my experience, there's a lot of customary actions that are not defined by law, but are expected of government officials.
Yeah, and
like telling the mayor to post this information.
Right, so,
nobody writes that in law, but...
Right, so we don't dispute that point, and I don't think the Sixth Circuit does either, but the critical point...
Oh, it does. It defines this much more narrowly.
Your Honor, if they do, we don't agree with that. But,
okay.
But the critical point is, in your hypothetical, how we know that that's state action is control. Your example was the mayor told the city administrator to do it. In the next case, the mayor couldn't have told the city administrator to do on this page because it's their personal property. That's not what's happening. And to go back to our case, there is no evidence in this case that anything...
So what do we do with what was then Twitter? I'm going to continue to call it Twitter because that's what it is here, okay? What do we do with Twitter where the blocking blocks, especially now, blocks access? Previously, you could still look at the Twitter account, you just couldn't post. What happens now if you don't have your own Twitter account, you can't even look? And if you're blocked, you're not permitted to look.
Again, it depends what you're being blocked from. And the critical point in these cases is that my clients, all of their speech was speech that they could perform in their individual capacity. Under this court's decision in Lane, even though they're government officials, they have the right to speak about the government in their individual capacity.
What if you showed a Facebook page to 1,000 people and 999 of them would think that this is an official page? Under your test, that wouldn't matter.
That shouldn't matter. I'll give you two reasons why it shouldn't. So the first, the conceptual reason, is because the challenge here is they're challenging blocking. And my client's power to block doesn't turn on the appearance. And here's a hypothetical that I think will make that pretty clear. Imagine you're a police officer, you finish your shift, you're running late to pick up your kids from school. So you go running down the street, still in your uniform, and you push someone out of the way. Everyone on the street probably assumes you're still doing your job and in hot pursuit of a felon. But that's not state action. You're acting in a purely personal capacity, and your power to push someone out of the way doesn't turn on your uniform.
Well, suppose the town manager has a page, and the town manager puts the official seal of the town and says, this is the town manager's page. This is the place to look to find information about what the town manager is doing, and this is the place to express your views on the important issues that come before the town manager. And there's nothing personal on the page, but the town manager doesn't use any public resources to create the page, and there's nothing in his job description that says that he has a duty to have such a page, and he's not relying on any special authority in creating this page. And you would say that in that instance, the town manager can block comments based on viewpoint. So the town manager can block anybody who expresses criticism of what the town manager is doing, and thereby create the impression that everybody in town thinks the town manager is doing the right thing.
So with one possible caveat, in your hypothetical, when he said that this is the town manager's page, if he was saying this is a page I'm running in my official capacity, then I wouldn't take that position. But by that statement has substantive content behind it. When you say this is the town manager's page in his official capacity, what you're essentially admitting is the town manager's boss could tell him what to do on the page. He's admitting at that point that it is a governmental page. But if instead, as I think your hypothetical was meant to suggest, he's just saying, I am the town manager. This is what I think. This is where you want to talk to me. That, under this court's decision in Lane, is what any government official can do in their personal capacity.
But why